Retail insolvency and Mosaic Brands, when suppliers become the bank. Welcome to IO Insolvency Options with Darren Vardy, the Managing Director of Insolvency Options and a registered liquidator with over 30 years of experience helping businesses and individuals navigate financial challenges. In today's episode, Darren explores the pressures facing the retail sector through the collapse of Mosaic Brands and its impact on suppliers, creditors, employees and consumers. He explains how rent aggressive acquisitions, extended payment terms, COVID disruption, and supplier funding can combine to create serious insolvency risk, even for well-known brands. You'll hear why safe harbour advice, independence, and conflicts of interest matter when major corporate failures are investigated. I'm your co-host, Anthony Pearl. Let's dive into unlocking more about insolvency options. Darren, let's talk a little bit of retail here. It's a sector which is really high on the list of those that are seeing them go into administration, and some well-known brands in that mix. Mosaic Brands is probably the one story that we can tell from the start. So fill us in a little bit about what's going on in the sector and about the Mosaic Brands story.
Yeah, sure. So retail insolvencies have jumped 37% in the December 25 quarter. So that's a huge impact. But when we talk retail, we talk everything from large multinational organisations such as Mosaic Brands down to, the local fish and chip shop. Now, I guess the thing to remember with any retail, quite often, one of the largest expenses for any retail organisation is rent. And where you have leases which provide for an increase in rent year on year at a fixed rate greater than CPI, quite often you will find that your rental cost as a percentage of income is starting to slowly creep up and become uncommercial or uneconomical. What you also have with that is when we look at, Mosaic Brands, it had been around for quite a long time and went through a rapid growth phase from 2015 through to 2019, where it sought to acquire the vast majority of the brands that existed at the time of the appointment of the voluntary administrators in 2024. Now, this business was adversely impacted by COVID-19 pandemic. It had to temporarily close 1,379 stores and stand down 6,800 staff in March 2020 to then work out what are we going to do with this business. So we're talking a very large concern. They've grown extensively with the various brands it had purchased, where COVID-19, because, we couldn't go out, we couldn't enter, we couldn't socialise with people, we're unable to go to the shops. The business almost effectively stopped overnight. Now, what it did do was to enable it to continue to operate in a different and more limited capacity. They raised some capital to stay afloat while the pandemic restrictions were on, hoping that it would ease. And it also pivoted into online trading. So during the 2020, 2021, they managed to limp along, and that wasn't without issue. They were fined in May of 2021 by the ACCC for making false and misleading claims pertaining to their hand sanitisers and face mask products. Then in September 2022, there were false claims regarding two other products. So there were issues. And then we had March 24, where the ACCC actually brought proceedings against the company for allegedly making false and misleading representations to consumers about their delivery timeframes and their rights regarding refunds or faulty products. And you may recall that was, in the papers in respect to the Rivers brand mostly. So after the company was placed into administration, or immediately when the company was placed into voluntary administration, its financiers appointed receivers and managers to try and realise the assets on behalf of the financiers. And the company was placed into liquidation in May of 2025, where the final debts are reported to be in excess of $318 million. Now, there are reports out there that the expansion strategy was quite convoluted and very aggressive, that it disregarded its suppliers, that they were acquiring already struggling chains or brands at bargain prices. But the expansion really stretched thin the company's resources. And so at the time COVID came along, it was already at its thinnest point, where the pandemic really was the perfect storm that really triggered the total collapse of the company. Now, I am, and I have been, the liquidator of 2 of its suppliers. And so I've got some inside information in regard to how those suppliers were treated by Mosaic Brands. Now, what I can say is that payables stretched from 120 days to in excess of 200 days, right? So by the time payment was being made, any stock that had been delivered had well and truly been sold. So even if a supplier had a valid security interest and was protecting its stock by virtue of a retention of title clause, that when the company went into liquidation, they had the ability to go in and say, well, that's my stock, you haven't paid for it, therefore I can take it back. Given the excessive payment terms, that stock certainly would not have been there for which any supplier could lay their claim over. When invoices were being chased by these suppliers, there were allegations that invoices had not been received, so therefore not accounted for, resulting in the suppliers having to supply them again, and in certain circumstances supply them 3, 4, 5 times, resulting in further delays in their invoices being dealt with and processed and to enable payment to be made. And what we also found was that towards the end, payments would be made, there were arbitrary deductions, no explanation, no factual or contractual basis for the deductions, which resulted in the suppliers having to then fight for what they weren't paid. So these were the things that had been encountered by not just the 2 suppliers that I've been appointed to, but by all suppliers. And when you look at the history of conduct, in my view, I think it's clearly evident that what Mosaic did was use their suppliers as their bank.
Wow.
Not the tax office, not a financier, but simply held their suppliers' payments to their suppliers back to enable cash flow within the business because the stock had been sold, which allowed for that aggressive acquisition campaign. And all of that then comes back to, well, at what point in time did the company begin to struggle financially? And that is something that to this day is still being part of an ongoing investigation, because where you have debts of a company in excess of $318 million, and granted, there's probably, think about $75 million relates to crystallised employee entitlements. So they may not be trading debts per se. Even if we say 240, 250 million in trading debts, we look at how long have they accrued and how long have they been outstanding for in circumstances where the very stock supplied by those suppliers has been sold in real time, but the debt has remained outstanding for in excess of 6 months.
It's a really interesting scenario, isn't it? And we're just looking at this at a high level at the moment. But that kind of situation is also begs the question that when did they realize that this was a problem, and who was accountable for not realizing that it was a problem much sooner, or what were they doing?
Sure. So in this particular instance, it has been identified that in or around the time of COVID, the board of directors and the executive sought to engage some professional advisors in respect to safe harbour, which is an insolvency mechanism to avoid any personal exposure liability for insolvent trading, and to prepare and enact a plan to attempt to turn the business around. Now, given the nature of this business and given the impact of COVID-19, I wouldn't expect anyone else in their position to do anything otherwise. I think it was a smart move to seek some advice from a safe harbour point of view to determine how they can proceed forward and turn the business around to ensure that they minimise any loss to its creditors at that point in time. A couple of issues come out of that, and they've been in the courts of late in respect to the actual insolvency practitioners appointed. And the issues that are playing out in the courts are in respect to, insolvency practitioners' conflicts of interest, because it was discovered that the administrator, one of the administrators at his former firm, Deloitte's, had actually been engaged by the company's external lawyers to provide advice on the safe harbour, only then 3 years later to be appointed as voluntary administrator of the company. Now, the issue that arises with that, and as has been, is that firstly, there's an independence issue. And I believe the rules are pretty straightforward, as they are for small business restructures, that if you do a small business restructure or you do a safe harbour, you cannot be the liquidator because you're not independent. So in this instance, one of the overseas creditors, one of the suppliers from China who was owed a significant amount of money, after attempting to remove and replace the administrators as liquidators through a creditors meeting, made an application to the court. And the court proceedings went on for some time. And during the course of the court proceedings, the particular administrator, liquidator, was cross-examined. And the judge, having regard to the nature of the conflict issue in the case, and notwithstanding the practical consideration against his removal, did not consider that that liquidator could continue to have conduct given the potential claims against the directors. Now, we've got to remember, it's the directors that you're advising on a safe harbour engagement. It's the directors that appointed this particular practitioner as the voluntary administrator. So even if there wasn't an actual conflict, there is certainly a perceived conflict, particularly where, given the extent of monies outstanding to creditors, over $318 million, one would suggest that claims would exist against the directors for insolvent trading, and that would need to be properly and appropriately investigated and, if necessary, pursued. Interesting enough, the judge also did not consider it appropriate for this particular practitioner to have conduct in potential claims against Hamilton Locke, which was Mosaic's legal advisors, or Deloitte's, because it's arguable that some claims may actually exist as a result of their safe harbour advice, all of which needs to be properly, appropriately and independently investigated. So in this case, what the judge did was order that some practitioners from Wexted Advisors be appointed as special purpose liquidator to actually pursue those claims that he thought was inappropriate for the incumbent liquidators to pursue. And that's all playing out in the courts as we speak, and will probably continue to do so over the next 18 months to 2 years.
Well, that's all we have time for in this episode, but next time on IO Insolvency Options, we'll continue the Mosaic Brands story and look more closely at the lessons for retailers and suppliers. Darren will explain why familiar brands are not automatically safe, how suppliers can protect themselves through contracts, retention of title, and PPSR registrations, and why income is not the same thing as profit when payment terms and margins are under pressure. We've created a workbook for the episode you've just listened to with some questions for you to answer, some key quotes, and action steps to follow. Check out the show notes for the link to download your copy. For details on how to get in touch with Darren and his team on insolvency challenges, please consult the show notes. This podcast is produced by my team at podcastdoneforyou.com.au, helping professionals share their expertise through powerful podcast content. If you found value in today's episode, please like, comment, share, and subscribe wherever you're tuning in to IO Insolvency Options. Until next time, remember, there's always a way forward when you know your options.